Hello, this is Matt on the Moon Family Sedan channel. Now, look, I don't know how Attorney John Deaton has the time or energy to do what he's doing, but my God, I love it. I absolutely love what Attorney John Deaton is. He just jumped into another lawsuit. This one is an XRP lawsuit, which actually predates the SEC attack against Ripple. So here's the headline from the Crypto Basic. Deaton plans to fight claims that XRP is a security in Zakhanov v. Ripple case. So folks, that dates back to 2018, and I'll share with you all the specifics, but oh yes, so you think about this. He's jumped in the SEC v. Ripple case as amicus, with the amicus brief, on behalf of about 76,000 XRP holders. Then during the remedy portions of the SEC v. Library case, he jumped in, and now he's jumping into this case. So that's three cases right there. I'll tell you what, if I were Attorney John Deaton, I'd just walk around wearing a cape all day because he has achieved superhero status. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, just as a hobby and just for fun. So just to quickly set the table, because I want to make sure that y'all know exactly what's being covered here. But again, this goes back about 5 years at this point. Here's a headline from CoinDesk. June 8th, 2018. Another investor lawsuit claims XRP is a security. Distributed ledger startup Ripple has been named in yet another lawsuit tied to the XRP cryptocurrency, court records show. Investor Vladi Zakhanov filed a class action lawsuit on Tuesday naming Ripple Labs XRP2, the company's licensed money services business, CEO Brad Garlinghouse, and 25 anonymous persons as defendants. The complaint was submitted to the Superior Court of California in the county of San Mateo. Zakhanov's claim centers around the allegation that the XRP token is a security controlled by Ripple. The suit states that Zakhanov bought XRP in 2018 and was damaged thereby. Now, folks, this is the stupidest damn argument, and you saw the same thing with that other guy. His name was Ryan Coffey. So these people, they're buying XRP as it's running to its all-time high, as it's approaching $4. They buy it, and then they almost immediately sell it. Like Ryan Coffey, if I'm recalling correctly, I think that, and I think all these cases, to be honest with you, there's been so many developments over the years, it's hard to keep it all straight, but I know a bunch of these various cases that were making similar allegations kind of got rolled into one. But with Ryan Coffey specifically, if memory serves, I'm pretty sure he held XRP for like a week and a half or 2 weeks or something stupid like that. That was it, and then he sold it. So if you're counting on Ripple to result in profits, you don't buy something and then expect Ripple to do the thing for you in like a week and a half or 2 weeks. It's so disingenuous, and it makes you wonder what the intent was, what the motivating factors are for these people. But it's hard to believe that this is genuine. And so anyway, in the complaint, dating back to then, this is what they wrote. Check this out. XRP, despite its name as a token, is actually a security under California law. In particular, 1, Ripple uses the funds it raised from the sale of XRP to fund its business ventures. 2, the company indiscriminately offers XRP for sale to the public at large. Let me pause right there. That's literally not true. Ripple has never sold XRP to people like you and I. It's not available to their holdings, not available to the public at large. Never has been. That's never been the case. And by the way, the idea of Ripple selling something they own to help profit their business venture, yeah, if you own an asset, you can sell it. If you own a bunch of oranges, you can sell those oranges. Maybe you're a grocery store to help fund your business venture. Like these things in and of themselves, no, that doesn't make any damn sense. Anyway, and then they also wrote under point 3 here, plaintiff and the class, as defined herein, are effectively powerless to control the success of Ripple and XRP, and 4, plaintiff and the class members' investment is substantially at risk and is without nay security, end quote. So obviously ridiculous stuff, and we know that the handful of people on planet Earth who have ever held XRP that hold that position, I mean, it's so few humans, it might as well just be a rounding error, you just round down to 0. That's how few people on the planet are arguing what he's arguing, which is why Attorney John Deaton jumping in, he's going to just destroy this argument. And so again, here's the headline from the Crypto Basic. Deaton plans to fight claims that XRP is a security in Zakhanov v. Ripple case. Attorney John E. Deaton, who represents over 75,000 XRP holders, is a friend of the court in the U.S. Securities and Exchange Commission case against Ripple, is set to request to join the Zakhanov v. Ripple case to fight investors' claims that XRP is a security. This is according to a Twitter thread from prominent defense lawyer James K. Filan yesterday. And I thought I'd just go straight to the source here and share with you what he had to say. So this is XRP community member and attorney James K. Filan sharing this news. And attorney Filan wrote the following. Hashtag XRP community, hashtag XRP. Attorney John Deaton will be filing a motion to file an amicus brief in Zakhanov v. Ripple in California. There, the plaintiffs claim that Ripple sold XRP as an unregistered security. They are asking the court to certify a class of all XRP holders who purchased and now hold XRP or who sold XRP at a loss. The proposed class would include XRP holders worldwide, including the 75,890 XRP holders around the world who disagree with the plaintiffs in Zakhanov and say XRP is not a security. So folks, think about this. The alleged potential class in the Zakhanov case would include you and me, everybody, even the people, the almost 76,000 humans that disagree. So you have like a couple people that feel like Zakhanov does, and then every other human on the planet. It's clearly absurd, right? So obvious. And so I'm glad that Attorney Deaton is jumping in here. This is incredible stuff. My gosh. And so anyway, Attorney Filan continues though. He says, also, the proposed class is not limited to direct sales by Ripple and includes all sales of XRP, including secondary sales and international sales in countries where XRP has already been determined not to be a security. I gotta pause right there, getting ready. So look, if it were the case that every single transaction, including secondary market transactions for XRP or pick your crypto, indeed would be illegal unregistered securities transactions, then crypto cannot exist. So if the Zakhanov guy gets what he wants, crypto just can't exist in the United States. That's the cold hard fact right there. That's the truth of the matter here. And it's completely and utterly nonsense, which is why I'm thankful that if you look at what happened in the SEC v. Library case, despite the fact that you find SEC won, and I don't think that was right, and we've talked about why before, in the remedies portions, even that judge who says, yes, SEC, you win, that judge says, no, secondary market transactions are not included. Yet here, in the Zakhanov case, they're arguing that every single transaction is an illegal, unregistered securities transaction. Basically, they're arguing that part is the same as what the freaking SEC is arguing. It's stupid. STLLPID, stupid. Really grinds my gears, folks. Really grinding my gears up good. Attorney Filan continues. Here we go. Attorney Deaton will argue, among other things, that the court should not certify the class because of these conflicts and because there is only a small number of XRP holders who claim XRP is an unregistered security, while so many XRP holders worldwide claim it's not. John Deaton will argue that those small number of plaintiffs in Zakhanov cannot fairly represent so many who disagree with them, including XRP holders in places where XRP is not even considered a security. That is awesome. And so, and this is all true. So Attorney Deaton, he ended up retweeting those comments from Attorney Filan, and Attorney Deaton said the following. Whether it's the SEC or a plaintiff's attorney making the absurd argument that secondary market transactions of a token are also securities simply because it may have been previously offered or sold in a way that violated Section 5 of the Securities Act, I'll see you in court. You gotta freaking love that. I gotta heart this one here. Exactly. And this way, again, I don't know where Attorney Deaton gets the fire, but my God, I love it. He's just bringing it nonstop. And he's right. And there's so much at stake. What he's doing is participating in something that is going to be highly consequential for decades to come, frankly. And this is the time to jump in and have at it. So I'm very glad that he is. But clearly what he's saying there is, even if there were illegal transactions facilitated with a specific XRP out of the, roughly 100 billion XRP that exists, even if they were transacted in such a way, that XRP moving to the hands of another human unrelated to the initial transaction would not be included here, which again is the same thing that was found in the remedies portion of the SEC v. Library case. And we're waiting to see the final technical write-up on that. But the judge is on the record. He's already said this is what he's going to do. So as long as he follows through with what he said he's going to do, and again, he's on the record, it's pretty clear that what these secondary market transactions that the SEC wants power over, no, they don't get to have power over them. And in the Zakhanov case, you're wrong too. And so thankfully, as reported by John Deaton's crypto law organization, the judge did approve this. You can see, I think I got it scrolled by. Here we go. So this is what's on your screen here. It's just Attorney Deaton's basically the application for admission to participate in the way as described in this case, in the Zakhanov case, and the judge did grant it. So that's good news. It reads as follows. It is hereby ordered that the application of John E. Deaton is granted, subject to the terms and conditions of Civil LR 11-3. All papers filed by the attorney must indicate appearance pro hoc vice, a service of papers upon, and communication with local co-counsel designated in the application will constitute notice to the party. And so there you go. So happy to see that. He's been allowed, frankly, all three places that he's sought to, be able to speak his mind on this. And he is right. And again, the consequences for all of this, it's so far reaching. I'm just glad that there is somebody like Attorney John Deaton who's actually going out of his way, because he doesn't have to do any of this. And he's doing this stuff, generally speaking, at his expense. So as far as I understand, he's just all this. Because look, he gets offered all sorts of thank yous, whether, strictly monetary or not. He's turned down it all. And so everything that he's doing here, it's at his own expense. He's just fighting the good fight because it's the right thing to do. That's the point. Cool stamp stuff here. So now we get to watch what Attorney Deaton is doing in 3 different lawsuits. I'm for it. I'm here for it. I'm here for it, son. I'm telling you. So let me know what you think. But that's the news to this point. We'll keep tracking it. Let me know what you think. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, family sedan.